Welcome back, everybody. Will Worsham joins us now for this week's Speaking Legal discussion, where he answers, of course, a viewer's legal question on the air. You ready?
I'm ready.
All right. Very good. Here we go. This is the question we got this week. I have been renting a house for 2 years, and I've had no issues with the landlord. I have no written lease. My rent is due on the 19th, but the landlord's been lenient and understanding and has let me rent, or rather has let the rent slide just a little with no penalties. But now, 2 days before the rent is due, the landlord contacted my parents and told them I have got to move out as soon as possible. He said he's having marital issues and needs the place for himself. The house is in great condition and looks as it did when I moved in, but this landlord's been known for keeping the security deposit. I'm wondering what my rights are and what you recommend. I want this process to be as smooth as possible.
Okay, boy, there's a lot there.
Great question.
Yeah, okay, first of all, no written lease. Horrible idea.
Is it?
Oh, yeah.
Lease protects both parties,
absolutely,
doesn't it?
because then everybody knows what we're dealing with and what the rights and responsibilities and expectations are. And when you don't have a written lease, essentially what you have is a month-to-month lease. And that means that either party can terminate that arrangement basically at any time. Now, they do need to give 30 days notice, so the as soon as possible thing is, you know, that would be a courtesy if you decide to move out as soon as possible. But the landlord can compel you to move if you don't have a written lease just by giving you notice and saying you need to move out. It's time. Your tenancy is over. If you don't do that, you would be in violation of the agreement, such as there is. You'd be considered what's called a holdover tenant, and they could file what's called an unlawful detainer action to have you removed from the house. The other problem with that situation is, in an unlawful detainer situation with a holdover tenant, you can get exemplary damages, like a multiple of the fair market rent of that property. So if the rent, say, was $500 a month, if you're a holdover tenant, which means you've been given notice to move, the 30 days of rent, and you didn't do it, the landlord might actually be able to collect like $1,000 a month for the time that you hold over. So
what if you keep paying your rent, though?
Well, it doesn't matter because you're not supposed to be in the property anyway because they gave you notice to terminate it. So they could do that, but you can't. The landlord-tenant stuff gets really sticky. Now, some of the other issues about keeping the security deposit and all that stuff, since there's not a lot of documentation here anyway, it sounds like there probably isn't going to be a lot of documentation going forward. First of all, how are you going to prove you gave a security deposit?
That was my next question.
Absolutely.
So, there's one problem. Maybe if you've got a canceled check and it says security deposit, then that might be something, but if you've been there 2 years, that might be hard to come by. The second problem is going to be there probably was no walkthrough done at the beginning of the tenancy, like where you go through with the landlord and you say, oh, well, you know, there's a hole in that wall when I moved in. So the landlord can say any damage that's to the property could have been caused during the tenancy because there's nothing to document what the condition of the property was at the time. What the landlord is really going to need to do is specifically supposed to schedule a walkthrough of the property at the end of the tenancy to show, okay, there's damage, this is what we're going to have to do, that, and we all kind of sign off on agree on what the damage is and that it was caused during the tenancy. Of course, that, you know, is usually the subject of a lot of disagreement.
Well, this person wants to handle it smoothly. What would you suggest that they do?
Well, one, they're going to have to move. I mean, if the landlord has said the tenancy's over, then the tenancy's going to be over, and we're going to consider that 30 days notice. So they're going to have to move out. The thing to do, obviously, is to work with the landlord and say, that's fine, let's get the security deposit issue worked out. Maybe it'll go well. Communication is the key to making anything go smooth. The more you talk, the more you communicate, the better chance you've got at things working out. We make assumptions about what people are going to do or what people are going to think. That's when we kind of get crossways and get screwed up. So communicate well with the landlord, first of all. Try to schedule that walkthrough to do a documentation of property. If there's any damages, not, and I said there's not, the landlord agrees, and they should give your security deposit back. If they don't, there's a remedy for that, and you can actually get double your security deposit returned if the landlord's in violation of a security deposit agreement. That's under a Missouri statute.
Now, security, that has nothing to do with normal wear and tear. That's extra, correct?
Yes,
Right.
that's normal wear and tear is the landlord's responsibility.
Right, okay.
There's a great resource for both landlords and tenants at the Missouri Attorney General's website. There's a little downloadable pamphlet that talks about the rights and responsibilities of landlords and tenants in brief. It's got some good information in it, and I usually refer people to take a look at that.
All right, sounds good. Will
Will, thank you
Worsham,
very much.
Thank
You're
you so
welcome.
much. If you have a legal question for Will, email him at wworsham@color10.com, and he will answer your question on the show.